Welcome to Riga. We are going to start off with the first panel. Excuse me. And the first panel is dealing with IT and legal tech and arbitration. It is moderated by Nils, Schmidt-Ahrendts from Hamburg. He is a partner with Hanefeld. And Nils has studied at the University of Freiburg. He obtained a PhD from the Institute for International and Private Law there. He's also teaching there. He's also one of the co-founders of the LLM excuse me, in international arbitration at the University of Humboldt in Berlin. And he is acting as arbitrator and counsel under the major rules of arbitration institutions. Nils, if you would like to introduce the speakers, the floor is yours.
Yes, good morning, everyone. I have the pleasure today to moderate the panel IT and Legal Tech in Arbitration. And the first speaker this morning is Solveiga, who is sitting second person from the left. Solveiga is a partner in Glimstedt law firm, and she's a professor at Mykolas Romares University. She has been teaching comparative tort law and international investment tort law more than 17 years. She's also designated a recommended arbitrator at the International Center for Settlement of Investment Disputes, in short, ICSID. And what I found most impressive, she was appointed in 2001 by Her Majesty the King of Norway, the Grand Officer of the Norwegian Order of Merit. And while I would be interested to learn what this implies, in particular, the presentation of Solveiga today will be about the use of IT and legal tech throughout the various stages of the arbitration. And I think, Solveiga, the floor is yours.
Thank you. Good morning, everybody. I'm really pleased, first of all, to be invited here and participate in this panel with outstanding speakers. And of course, very honored to be the first this day after yesterday, intensive and nice evening. So my presentation will focus mostly on challenges we meet when we have virtual arbitration, to share our experience, because we have already 2 years of COVID, during which we were forced to switch off from oral hearings, usually oral arbitration, to some kind of fully e-arbitration and virtual arbitration. Actually, with James, we decided to share this topic, and for me, it was an idea to speak more about challenges or some kind of disadvantages of virtual arbitration, and James will focus mostly on advantages and more positive things. I myself, when I was thinking how to present this topic, I really realized that in general I am in a big risk to be very unpopular today, to speak mostly on disadvantages or challenges we meet in virtual arbitration, because taking into account with what power, let's say, and enthusiasm arbitration community, including arbitration institutions, were promoting virtual arbitration, how many efforts they put to thousands of instructions, recommendations how to conduct virtual arbitration. For me now today to speak about challenges and some kind of disadvantages, it's risky, let's say. But in any case, we have to accept that there are lots of challenges we have to cope with when we decide to have virtual arbitration. So there are thousands of articles, discussions in internet about different kinds of administrative issues we meet, about security, cybersecurity concerns, about challenges concerning obligation to ensure fair process, to obligation to ensure, let's say, right to be heard and right to present the case. So my idea was not to be too much focused on detailed technical issues, but to be more general, to bring to the audience some kind of considerations. And I identified, let's say, four of them, based on which we have to decide, and a particular arbitral tribunal has to decide whether to have virtual arbitration or let's have virtual hearing in a certain case, or whether to have still oral hearing, especially now when the COVID is over and we can somehow step back or still continue to have virtual or go again back to oral hearings. So first, my consideration is based on the idea that we have to accept that all challenges for virtual hearings, they can be overcome. All problems in general can be solved. You cannot say that there are problems that you cannot solve, that there are deadlocks. We saw during this COVID period that, for example, complicated cases were somehow successfully being conducted virtually, and there were, at the end of the day, no problems. But the point here is that at what price? Because usually we use and now promote virtual arbitration instead of oral hearing, for example, on the idea that we must have efficient proceedings, not so costly, not so expensive. We can have cheaper proceedings by virtual hearings as a rule. It is accepted, and also what is maybe even quicker. But if we have complicated case with thousands of evidences, and with number of witness examination, so at the end of the day, we can realize that the proceedings may be much more longer and maybe much more expensive. So that's my first consideration. Second consideration is that what we have to accept, that conduct of arbitral proceedings and advocacy in completely virtual arbitration, in virtual, let's say, hearings, they are different. They are not completely the same as in oral hearings. So preparation proceeding, for example, even technical questions you have to solve to discuss with the parties during case management conference or in later stages, there are much more questions which have to be solved, starting from purely technical issues, internet connections, accessibility, different time zones we meet when we organize virtual hearings, what kind of software we are going to use. Even we have to think about having additional company or person, not only secretary, but IT specialist. So it takes more questions to be and more issues to be organized during virtual hearings, and in general, advocacy in itself differ. And everybody knows and accepts and writes a lot about how to conduct this cross-examination of witnesses. It may be much more complicated, and the way you have to do this now is different. So that's the second consideration. Just need to accept that advocacy and conduct is different in comparison with oral hearing. Third, my consideration is that in general, but you have also to accept that we are humans, and we are humans with all senses, 5 senses or even 6 senses, and neuropsychologists, they could confirm this, but we make decisions with all our senses. It's not purely a question to make decision and conduct proceedings just purely based on legal argument on submissions. The decisions are made, advocacy, presentations are made with all our senses, with our smells, we hear, we feel, we see, and so on. So in general, we have to take this in consideration, because during the arbitral proceeding, the first point what we have to do, for example, if you are counsel, you have to be convincing. You want to be convincing to the arbitral tribunal, and you want to keep the focus of arbitral tribunal to your statement, what you speak, and all senses they matter. And in general, when we speak about virtual hearings, also lots of articles and surveys has been made. A new phenomenon has been identified, like Zoom fatigue. The idea is that in comparison with oral hearings, people during long hours having hearings through Zoom, they become very tired, much more tired in comparison with the conduct of oral hearing. And the problem and challenge how to keep focus of arbitral tribunal, members of arbitral tribunals, focus on the statement, on argument, and not only on IT issues. So it's an issue. And again, so we are humans. Otherwise, we could even exchange arbitral tribunal and humans with artificial intelligence. Why not? But still, we understand that we need humans and people to decide our cases. And my fourth consideration is even more, let's say, general one, conceptual one. It's the question, answer to the questions, what we are looking for and what we are seeking with our case, the arbitration proceeding. Is it enough just to follow procedural rules in order to ensure fair procedure, right to be heard, safeguard of right to present your case? Or we are looking also not only for procedural justice, but also for substantial justice. To my opinion, substantial justice is also very important, in even sometimes much more important in a broader sense. It's not about only individual arbitration case. It's about also arbitration as a dispute settlement mechanism, as reliable and respected one. We have to be convincing not only for arbitral tribunals, but we have to be also convincing for the stakeholders, main parties, or our clients. They must believe, they have to believe that their dispute has been solved properly. They have to feel it somehow. So substantial justice also matter, because arbitration is alive only as far as it is respected and reliable and have reputation. So the main, our clients, stakeholders, clients, have to be happy and satisfied with this. So this is my four, let's say, consideration, based on which I just wanted to pay attention to the main problem, but there is still a problem, even if we have virtual arbitration. And at the end of the day, even though we can solve them, it may cost us much more, and it may take much more time to organize everything properly. So sometimes it's better just to have oral, traditional hearing to make ourselves and our clients happy. That's it.
Thank you very much, and I think it's not risky, but perfectly fine to start the day and this topic maybe with a critical perspective. Our next speaker probably will enlighten us that while we are humans, and he probably also wants to make sure that the tribunal is listening to him at a reasonable price and without being hacked, that there is the possibility to conduct hearings virtually, but also to use other technologies in the course of an arbitration. The next speaker is James Lewis. James is a partner with FIELDFISHER in the London office. His practice covers commercial litigation, international arbitration, for clients from a wide range of industry, as it is often the case in this field, sectors including banking, energy, technology, and trade. And one of the reasons why he may be sitting on this panel is that in late 2020, he was involved in the longest fully remote hearing, I understand, in front of a London court, was that? That's right, and no one fell asleep during that time.
Keep an eye on everyone.
Yeah, but tell me, anything else went wrong? Was there some other reasons why you would be concerned about using technology and IT in arbitration, James?
Well, I'm not going to set up at this hour in the morning a big spat between myself and Solveiga, because I think actually we're probably a bit closer to each other than it's maybe being set up. But we wanted to get your attention this morning. I should say at the start that one of the benefits of technology that I noticed was doing video conferencing. You could do a very good job of speaking on screen without any notes at all by putting them just to the left of your screen. And everyone thought you were speaking just like Solveiga did without any notes at all. I've been exposed here, I've got my notes here, so I can't use the technology to my benefit because we're here in person. So excuse me for some notes that I do have in front of me. My assumption is that everyone here broadly thinks that technology is generally a good idea. I don't know, unless there's anyone who wants to raise a hand at that point in my presentation. I think if you look at how arbitration institutions have looked and approached technology, you know, they've been relatively proactive. I mean, well before COVID, you had reports from the ICC back in 2017, the Commission report on IT and international arbitration. There was, in 2018, the Chartered Institute of Arbitrators, a protocol for e-disclosure in international arbitration. So I think the issue of IT and legal tech has already been out there for many years. But what I found interesting is that there's also a recent ICC Commission report on what they call leveraging of technology for fair, effective, and efficient international arbitration proceedings. And part of that report included a survey of practitioners. And two figures caught my eye. The first was the result that 93% of those asked agreed that technology has improved the efficiency and cost effectiveness of the process. So I think we can take from that that technology is probably here to stay because it seems to be working. The other figure is that 83% of those asked agreed that technology has been underutilized in the arbitral process. So we've got a slight mismatch. We've got the idea that a lot of people think that technology and the use of it is good in the arbitral process, but actually we're not using it enough. And that might be something I'd be very interested on people's views as to whether they agree with those practitioners who responded to the survey. So I'm going to look at some of the factors surrounding the benefits of technology and maybe why we might want to embrace it further. And I'm not going to get too technical on this. It's quite conceptual as well. Firstly, where can technology make a difference? I think technology does bring the benefit of efficiencies and smart solutions. So I think we probably all have dealt with arbitrations where there's been a lot of data at stake, a lot of documentation. I have experience of dealing this both in arbitration and litigation settings. I think tech can bring something to the party here. You know, whether it's for data gathering, data review, document, purely just to assess what documents are supporting your claim, let alone then dealing with document production requests on the other side. So I think the technology that's now available, whether it's data mapping, extracting information from images as well as messaging, whether it is the different terms of clustering and other technological AI-driven tools, I think they can all bring efficiencies to a situation where there is a lot of data and documentation to be dealt with. I think there's a benefit also to some of the new online case management systems that are available. I know that the ICC is developing its own particular model for users to have the benefit of. There is a data security issue. I totally agree. But I think this really exists with any technology we use. I mean, what is the big data risk with email? You send it to the wrong party by mistake. You CC in the wrong person. The predictive text for that email address goes wrong. Does that mean we don't use email? I don't think that would be the case. I think it proves the point that usually it's not the technology itself, it's actually human error that causes the problem. And so the more that we can actually learn and get the skills of the IT and the technology, as well as, as much as we think we know are very good at email and other, what we call basic IT skills, if we can bring that into the other tools that are available, I think the risk is fairly minimal. As to virtual hearings, Solveiga has done a nice coverage of the kind of issues at stake there. And I think there is certainly an issue about whether there is a fair hearing to be had. I take issue slightly, and I'm not going to pick on language in particular, but when you say the idea of it's either an oral hearing or a virtual hearing, I think really you can have an oral hearing virtually. And I think that's an important thing that I think practitioners need to sort of get on board with. So you can, it's still an oral hearing, even though it's over a video conferencing situation. I've also had feedback that you can have a pretty good look at a witness when they're right up against the screen. And you can see every facial change and reaction to what's being put. So that, I think it's not, the jury's out, I think, as to which one people prefer, because they both have benefits. I do agree that there's something about being in the room, like we all are here. You get a sense, a real sort of sixth sense, as you said, of how people are. I think technology then has, the impact of the COVID pandemic has probably meant that people have realized that actually some of this technology is very good in a way that they may not have had the appreciation before. The second area, I think, is another factor, is technology for the sake of sustainability. And I think this is becoming a very important point for all of us in all our lives. Most firms probably now have their own ESG policies, their sustainability mission statements, and that's not just for show, it makes sense as well. There's been research done by, I think Lucy Greenwood was mentioned by Juliet yesterday. Obviously, she's made a lot of strides in campaigning for greater, greener arbitrations. And they did a very interesting study trying to take a sort of a classic arbitration case and saying, what is the impact? What's the carbon footprint impact of that? And the two biggest factors that came out of that are paper bundles and travel. A lot can be done to reduce that carbon footprint by getting smart on documents and not printing off big bundles and only traveling when you really have to. I think another factor which probably brings together both the first two and some other factors is what clients expect. I think clients are using more and more technology in their own businesses and expect us to use it too. Otherwise, we seem a bit archaic. We seem a bit out of date. There's a quote from a recent in-house counsel at Goldman Sachs who says technology spend will grow and people spend will decrease. Analytics and artificial intelligence are no longer just best practice. They are the practices. And I think in so many industries, tech is being used more and more for efficiencies, and we're going to be a little bit back in the Stone Age if we don't adopt it too. Clients, I think, also value sustainability. It's often baked into their corporate setup now. And for some large clients, they will require their service providers, their lawyers, to embrace the same kind of principles as well. But also, there's the cost issue, which clients will also be very grateful for, to understand that the efficiencies and the savings that can be made from technology. I think one other factor is the need for arbitration to remain a preferred dispute resolution method. And this probably comes from my perspective as practicing in London, where for international disputes, I feel that clients do sometimes have a real choice between using the court system, the London Commercial Court, or using the arbitration process. And there is a bit of a healthy competition between the two. And they do look over the fence at each other and say, well, what are you doing? What are those practices going on? Maybe we can adopt them into our side. I think a classic example of that is the way in which, due to the English disclosure process, which has always been a bit more onerous than some of the more European models, a lot of the technology to try and deal with that mass of data has been used for longer, and the courts have had to grapple with that a lot more. And what it's driven is the idea that courts can say, okay, I understand now that these technologies offer a viable solution. And when you come to me with a statement that says, we've used this tool to analyze the data, it's trustworthy for these reasons, the court is willing to accept that as a way of dealing with that challenge as part of the arbitration, as part of the court process. I can see that procedural orders in the arbitration world are starting to embrace this, and I think it's probably an area that will increase as well. So I think where does this leave us in terms of action and going forward? I think as Juliet Branch said yesterday, you need an arbitration process that is fit for purpose, that is really at the cutting edge. And so if you think about the different stakeholders, I think the institutions need credit. They have made strides. I think they've moved to update their rules, issue guidance, try and envisage the situations where technology is going to be used and how it can be best used. I think the arbitrators probably are starting to come along with it. I think if you believe Juliet, they need a little bit of help still, maybe a bit of training. But that could be done. Maybe we can help that out by only picking arbitrators who we think actually do have some IT skills, because it's quite important these days. But I think we have a role to play as well, as the users of the process, to know what technology is out there, and so that we can best advise our client on what would be suitable. And I will stress that technology shouldn't be used just for its own sake. It needs to be fitted to the right case. And some cases will require less, some might require more. But to know the range of options, the menu, I think is very important. Feedback to the institutions on how rules and guidance can be updated. And then, as I said before, select arbitrators who we think are going to support that approach of being a bit more friendly towards technology and adoptive of technology. So those are my thoughts, and I'll leave it there. Thank you.
Many thanks, James, and I agree. I think the starting point for the use of IT and technology in arbitration really is to have a better understanding of the technology which exists and what are the options and which are the opportunities out there. And when Thijs asked me to moderate this panel, I accepted the invitation not because I considered myself the most prominent IT expert ever in this field, but rather because I was looking forward to hearing from the speakers what is this cutting-edge technology which is available on the market. And I think, having now heard to broader perspective, we will go into a little bit more techie details. And the third speaker today is Guillard. She's an associate at Shearman and Sterling in Paris. She's a board member of the Ukrainian Arbitration Association and is the first foreigner to be appointed to the Young Istak Executive Board. And Anna is also one of the co-founders of the group I-ArbAfrica. And her presentation today will be the financing, litigation and arbitration through tokenization. Anna, the floor is yours.
Thank you. Thank you, Nils. Before moving to my presentation, I would like to thank Thais and Galina and all people involved in the organization of this just perfect conference. I've heard so many good feedbacks from my Ukrainian colleagues, how it's nice to come here to spend the evenings on the beach. So it's just, I hope that next year we will see here more Ukrainians and we will celebrate our victory together. Thank you. And also I would like to thank Latvian people for support of Ukraine. I was in Warsaw 2 weeks ago, and I saw many Ukrainian flags, and I came here seeing also many Ukrainian flags, and it made me nostalgic wanting to go to Ukraine more, but it's very nice to come somewhere not Ukraine and feel like home. Thank you very much. Okay, now back to the use of technologies, and I just wanted to say a small comment on what James said about when you see a screen with the face of an expert or an arbitrator. And I think that while technology continue to advance, then we will have some programs which will be scanning all emotions to see the reaction of the eye, so it will be like reading everything that this person says or even maybe thinks or about what. So it's a little bit scary. Okay, so we know that already blockchain technologies are used in healthcare industry, in real estate, in encrypted communication. At the same time, the use of technologies in blockchain technologies in legal tech is quite limited, and maybe now its time is ripe to change it. One of the recent developments is the use of blockchain technology to raise funds to finance litigation cases and arbitration cases. So in late 2020, 3 entities came up with an idea to raise funds through tokenization. They were Avalanche Lab, so it's Avalanche Blockchain, a New York-based law firm, and Republic, an investment platform. So the idea is to sell a part of legal right to a recovery through online, and then once the case is over, so this person will have right to claim a part of this recovery. The idea itself was advertised even not only in legal community, but also by one of the co-founders of Avalanche Blockchain, as to provide better access to justice, because we know that sometimes even arbitration is being criticized for being too expensive when small claims or claimants with important claims, but they don't have enough financing, and they can go against big corporations or states who have much better means to protect themselves. So the first idea is to provide greater access to justice and to increase the pool of claimants. And second aspect is to change, to democratize investment market and to let retail investor enter this market and have opportunities to diversify their investment portfolios. So initially, this was the first case, and the claimant in this case suffered from his cannabis field being destroyed by a state, and it was around 1 billion worth of hemp crop. Initially, they planned to raise 5 million, but they raised only around 400,000, and now still this case is pending. They were inspired by this experience and decided to create an investment platform and start selling claims through this platform. They initially planned to launch it, I think that COVID prevented, in 2021. Now the aim is to launch it in 2022, and on website there are only limited information, but they promise over 50% annual income. So it looks like too much optimistic. This idea was already criticized for being like not very wise for uninformed investors, because on one side, how you can assess the claim, and if you're not a lawyer, or even if you are a lawyer, how many information you need to review to take this decision. And on the other side, also, if you are not an expert in blockchain, or even you don't have any knowledge about blockchain, and you just think, oh, it looks interesting, but then you can be very disappointed. And we've heard already many cases when people were disappointed by crypto industry without just thinking that they can gain money too quickly. It's seen as an opportunity, and one of the founders says that, okay, yes, it's difficult to predict the outcome of a case, but if we take as the lead investor a funder, and I think that I see Jacob in the audience, and maybe he can say a couple of words on the side of the third-party funders, how it can be organized. And one of the issues, so it's for litigation and for arbitration cases, I think that the main concern will be confidentiality, because in order to present your case, you need to reveal information, and the majority of arbitration cases are confidential, and especially like this long, 1,000-page contracts, construction contracts, they're quite complex, and also they cannot be made public. So we will see if it will be applied in arbitration. And other aspects, so here to take in consideration is blockchain technology, and now there are many initiatives to popularize them, to make the general audience aware of their advantages. Second aspect is the regulatory challenges. We know that it's not a secret to anybody that crypto regulation is not stable, that different countries are now seeing crypto as a way to use it for money laundering, or even to finance terrorism. So it's just like you're running after something which is constantly changing. And third aspect is the contract to be concluded between the platform and the potential investor, how the investor's rights are protected, and how much information this person then can use to protect his or her rights. So we will see. This is an example of a litigation. Another example is the financing of an investment claim. Maybe you've heard of a case, Eurogas against Slovak Republic. This case was dismissed in 2017 by a tribunal consisted of Brigitte Sturm, Emmanuel Guillard, and Pierre Mayer. And now, 5 years later, the claimants decided that, okay, let's try one more time. There was a decision of a US court in 2019, and we don't know why they waited for 3 years. So they created this website, advertising, again, opportunity for retailer investors to get access to huge revenues. But when I went through this, and why I took this example, because one of the things that the most important for lawyers is reputation, and for crypto projects also reputation and trust. And while creating not trustworthy projects, it can impact the whole industry and the whole vision of future of this project. So on this website, they don't provide too much information on the case itself. there is no description of the process of the investment arbitration, which sometimes the cases can last for 3 years, 5 years, then you have annulment, then enforcement also, like we know UCAS, 8 years later, still trying to enforce. And because it's not only because against Russia, but because there are different mechanisms that can be used by the respondents to protect themselves from the enforcement. Also, in almost all the crypto projects, one of the most important parts are Twitter and Discord, where they publicize information about their projects. And for this project, they created Twitter, but it's not active, and it has just a couple of followers. And at the same time, they say, okay, we raise this money to use for advertising and for lobbying interests. So it's very contradictory. And Discord, even the link is not active. Also, this website does not provide too much details on tokenomics. So in general, it creates an impression that they read somewhere about this possibility to do initial litigation offering, and they thought that it can be a good opportunity, but they did not think of all details, and they did not create a whole team with developers, marketing team that would really round up it as a trustworthy project. And I was also thinking that in case of investment claims, what can be the biggest risk? And I thought that, okay, usually investment claims, they're huge, sometimes billions of dollars, euros. And if a state would like to protect itself, and at the time of sale for a case aiming, I don't know, 1 billion, it can buy these tokens for 1 million. So then even if the state loses in a couple of years, just, okay, I'm safe. I lost just 1 million. So we will see how it will evolve, and I will tell more about issues with disputes in blockchain, involving blockchain technologies. But I think it's one of the most exciting developments, and we will see how many more cases will be able to be financed through this procedure. Thank you.
Thank you very much, Anna, for what I think is really one of those topics who are at the brink of becoming very relevant in our daily practice. And we will stay a little bit with the crypto world. Our next speaker is Aija Leyniece. Please correct me.
Aija Leyniece.
And she's an independent counsel and arbitrator based in Paris. Aija has over a decade of experience in public international law and commercial arbitration, including from her previous practices at bigger firms such as Latham Watkins, Clearly Gottlieb. She has represented clients in high-stakes international disputes across a broad range of jurisdictions, business sectors. She's been going solo and has also branched out into crypto disputes, and most notably, Aija has recently advised traders against the world's largest cryptocurrency exchange for losses suffered as a result of the platform's failure. And since this is an IT and technical panel, we will have a presentation with us today, and Aija, the floor is yours.
Good morning, Labrit. So my name's Aija, nice to meet everybody. It's really nice to be here today. It's my home turf because I'm actually Latvian, even though I've been in Paris for the past 11 years. So I'm happy that Thijs is organizing this. Thank you for inviting me, and I hope everybody enjoyed the beach yesterday because we were lucky with the weather, it didn't rain. So, and thanks Anna for warming up the blockchain topic for me. I think this is a very interesting and very current topic, and I think it also continues the question that Juliet and Ismail asked in their presentations yesterday, meaning that can arbitration keep up? Because there's a lot of new technological evolution happening. And we as service providers need to be able to keep up with those developments, with an evolving economy, and also with an evolving clientele that has different needs and that has, most importantly, absolutely different expectations. So the first blockchain protocol, the idea for it was proposed in the 80s, but it really took off in 2008, where a mysterious figure called Satoshi Nakamoto invented Bitcoin in a white paper. And since then, blockchain technology has created new commodities, new financial instruments, and most importantly for us, new relationships that we have to deal with. And I think there's going to be a lot of repercussions for dispute resolution. And to answer the question, can arbitration keep up? Yes, I think we can, and I think we absolutely should. So very often when you speak about blockchain disputes, the first thing that comes to mind is automatization and smart contracts. So this is an example of a smart contract, which looks like gibberish because I'm not a programmer and I imagine not many people here are either. And a smart contract is basically the parties come to an agreement as to what they want the content of their agreement to be, then they find a programmer, and the programmer comes up with code. You can also add arbitration into that code so that everything would be executed automatically. And the way that happens is both parties would put a certain amount of money in crypto in a crypto wallet, and once the arbitrator comes to a decision, they have a private key, they enter the decision on the blockchain, and there's an automatic enforcement. So there is no need to go the enforcement route, no need to chase assets, no need to do anything. So it's a really attractive method of contracting and also of dispute resolution. And this may leave a lot of people wondering, will blockchain disputes make lawyers obsolete? And to that, my answer is no, because as much as technology evolves, we are still the descendants of Cain and Abel, and at some point somebody's going to get smashed on the head. And that's when lawyers are going to come in and clean up the mess. So just to evoke, because this is not I'm not going to do a substantive presentation. I don't have 3 hours and go into the details, but just to give you an idea of the type of disputes that we may face. So first of all, you can have disputes about the smart contracts themselves. For instance, there could be fraudulent or negligent representations made by the parties as they are getting to an agreement as to what they want their smart contract to look like. The code may be incorrect, and there can be coding errors, in which case you could technically also potentially go against the programmer or the other party. There could be illegality in the smart contract, and also there could be issues of a party's capacity to enter into a smart contract. And all of these issues, at one point or another, can lead to litigation, either arbitration or national court litigation. And another topic and another category of disputes that I think is going to be, actually no, apologies. No, we're good, sorry. Another thing that's going to happen is consumer and user disputes, because there's a lot of actors in the crypto space and in the blockchain space. For instance, if you want to buy cryptocurrency, you need to open a crypto wallet. You need to buy the currency from a provider or an exchange. For instance, the first row is MetaMask. MetaMask is a wallet provider. Coinbase is a platform. OpenSea is a place where you buy NFTs. Binance is the largest crypto trading platform in the world. And a lot of these companies have arbitration clauses in them. The issue is that right now, I recently attended a conference in Paris, and I got to meet some of these people, and they're thinking a lot about regulation because they don't want to get in trouble in jurisdictions where they're based in, but not a lot of them have really thought dispute resolution through, and there's a lot of consumer protection issues. For instance, on OpenSea a couple of months ago, so OpenSea sells NFTs. NFTs, just to give you a very short description, the easiest way to understand them, it's a piece of code that designates basically a JPEG picture of something. Very often it's collectible. And there was this one collectible collection that is called the Bored Ape Yacht Club, and one Bored Ape sells for up to $300,000. And one of these Bored Apes was sold for $30,000 because the person who entered the price on their account accidentally pressed enter too early. And that was not blocked. So for instance, had it been a financial instrument and it had been an actual trade, that transaction would have been blocked. So there's going to be practical issues that arise with the use of all of these platforms. Or for example, your NFT suddenly disappears from your crypto wallet. Like, who do you sue? How do you, And a lot of these companies, as I said, have arbitration clauses. So for instance, there's AAA, there's a lot of JAMS, there's some ICC, there's Hong Kong, there's CPR, and also ad hoc arbitration. And all of these disputes will need both arbitrators and lawyers to figure them out. And then you'll have a layer of novelty on top of already familiar disputes. So you can have just regular commercial contracts or shareholders agreements between crypto actors, and there maybe you don't need to understand the technology to the T, but it's much more helpful if you come into a dispute either as counsel or as arbitrator already understanding the basics, so you don't have to learn everything from zero. And another interesting point I'd like to make is that these are different types of clients. I've worked with the community and they want everything fast, especially traders. They want everything yesterday. They want everything, three times everything has to be bigger, bolder, and faster. And they're not really impressed by arbitration. In one of my cases, somebody called me and they were like, Aija, what do you think how long is this gonna last? 2 months? And I was like, I wish, but probably not. So it's a different type of clientele. It's not, and the other thing about the crypto community is that there's people from everywhere. It's a global community, and it's also very global in terms of who the participants are. So it's not going to be the director of a company. It's not going to be somebody who's the minister of justice or anything. It's a different type of client, and that's something that we need to keep in mind when working with these people, and also when trying to attract new clientele. Then, of course, you can have crypto or crypto-related assets as the objects of a contract, for instance, trading crypto or selling crypto or trading NFTs. Then you can have NFTs as loan collateral. That has functioned a little bit, at least it's been advertised. For instance, if you own one of these Bored Ape NFTs that I just mentioned, there's a company that offers you up to sort of $500,000 as a loan if you put the NFT up as collateral. That obviously all depends on whether the NFT market will blow up or not. We'll see what's going to happen with it. And then you have crypto as payment, which is also an interesting aspect because arbitration lawyers, because of, we work a lot with money. We're either chasing clients to pay us money, or we're chasing the other party, we're trying to enforce something, or obviously our aim at the end of the day is to get compensation for our clients most of the time. So for instance, crypto as payment, very often crypto clients will not want fiat, they will not want government issued money, they will want the crypto that they lost because they have confidence in the market and they think it's going to go up. For instance, if somebody, for whatever reason, loses 10 Bitcoin, very often they'll just want that specific, they'll want 10 Bitcoin. And it can be really difficult because, for instance, if under the laws of England and Wales, you basically it's the same as asking for that specific camel or that cow because it's not a currency. It's basically a digital object. So I think there's going to be a lot of evolution on that side as well. And then the final frontier, investment treaty disputes. It may seem a bit far off now, but I don't exclude the possibility of crypto and blockchain getting into investment treaty arbitration. So for instance, there's national cryptocurrencies. There's the failed Petro in Venezuela. And national cryptocurrencies in Venezuela, they were backed by oil and gas reserves. It never took off, but I can totally see governments coming up with cryptocurrencies, especially in places where there's economic problems and you need a boost to the economy. And I would see national cryptocurrencies somewhat as sovereign bonds that could also lead, as we all know, to investment treaty cases. Then there's cryptocurrency mining farms. A couple of months ago, some of these crypto mining farms were seized in Serbia because they were using too much electricity, because mining Bitcoin takes a lot of, it's not environmentally friendly, let's just say that. So there could be issues relating to those as investments, because a lot of these treaties, a lot of these investment treaties have a laundry list definition of what an investment is. And honestly, I don't see why a crypto investment or even just buying national cryptocurrency would not fit into that. Then you could have crypto-related government contracts. And then obviously, legitimate expectations of a crypto investor in case you put new regulations into place, which is happening pretty rapidly all around the world. I think crypto and blockchain started off as this very idealistic thing, and obviously in the beginning, Bitcoin was used for all sorts of criminal activities, including murder for hire and heroin trades and all these things on the Silk Road. But the reality is that it's actually not some sort of dark horse. It's just, in the beginning, law enforcement and governments didn't have the knowledge to work with that technology. For instance, nowadays, Bitcoin and all cryptocurrencies are super traceable. If you have the address of a wallet, you can trace the assets, where they go to, and what happens with them. So it's gonna, and I think as more and more regulation comes into place, it'll become more and more commonplace, because that's what happens with assets. The moment you regulate a class of assets, suddenly everybody feels comfortable and they buy it up. So I think that's what's gonna happen. But as new regulations come in, those can also affect the expectations of investors and end up in arbitration. So yeah, for us, I think we need to educate ourselves. We need to be able to orientate ourselves in these types of disputes and be at the ready. And some of the issues that will come up in these arbitrations is enforcement and seizure. For instance, if you know a wallet's address and you know that belongs to the other party, how can you seize it? There's a great article coming up on that in Delos arbitration, where Anna is also contributing on tokenization of litigation financing. And we have somebody writing on how they managed to seize a crypto wallet in France through French courts. Then there's also preliminary measures. For example, can an arbitral tribunal put a freeze on a crypto wallet? Or can they compel a party to convert crypto in a specific wallet into fiat for the other party in case there's massive fluctuations in value? Then there's also the question of specific performance. Can tribunals order specific performance if that's what the parties are asking for? Then there is an interesting issue of damages valuation, because, for instance, in these platform crashes, how do you value those damages? It's really, really difficult, and that's something that a lot of damages experts are also working on. Because it's a novel field. And as I said, there's going to be completely novel disputes, but at the same time, there's just going to be an added layer of complexity on things that are already familiar. And yeah, I think we can and should keep up. Thank you.
Many thanks, Aija, for what I find a fascinating contribution. And having sort of touched upon the crypto world, we will now take a regional focus, and the next presentations will not be in person, but will be virtually, and maybe we wait until she's on the screen. Can you sort of put on the screen? Leyou, do you hear us?
Yes, I hear you.
Hi. Good morning, Leyou. For the audience, Leyou Tameru is an arbitrator and an expert in international arbitration specialized in Africa. She's the founder of I-ArbAfrica's online arbitration hub, which also hosts the podcast Africa Arbitration. Leyou is an ICC court member for Ethiopia, and she's on the list of arbitrators and centers in Asia and Africa. She regularly advises African governments on arbitration and treaty-related matters. And so the topic of today's presentation of Leyou will be legal tech and arbitration in Africa. and we are looking forward to hearing from you. We are sorry that you're not with us, but happy to see you at least on the screen.
Thank you very much, Nils. I am absolutely gutted for not making it to Latvia. I was very much looking forward to it. Unfortunately, I had to deal with COVID. We think that it's over, but just when you think it's done, it's not. So I'm very sorry to not be making it. And I'm sure everybody's having a wonderful time in Latvia at the moment, in Riga. My discussion today is going to focus on the region, the African region, but I'm kind of going to, dial it back from the very tech aspect and kind of try and bring it back there, but get back to the basics in terms of what impact technology and IT has had on arbitration, but also specifically arbitration in the African continent. Now, one of the main things that we've seen come up with regards to tech here is, and the reason I even founded I-ArbAfrica about 7 years ago, was because Africa was considered to be a consumer of arbitration and not a place for arbitration. And I think that's a very important distinction. So a lot of the arbitration that happened that concerned African parties was not in Africa. It was outside of Africa. And, and nobody really, to be honest, and to be quite frank, actually, it might be a bit controversial, nobody really took the African continent seriously when it came to that as a potential contender for space for arbitration. So that's one of the first things that we wanted to dispel when we started the I-ArbAfrica platform, was to say, okay, are we really consumers of arbitration only, or are we also capable of having, becoming the space for arbitration in the world, right? So by collecting data, specifically information, just, it started from basic, like, let's collect news. Let's put the news information together and see what news is developing with regards to arbitration in the continent. But then it got more deeper, where we started now collecting information specifically on enforcement of foreign arbitral awards concerning African parties within Africa. So kind of analysis of enforcement regimens in the African continent, but also concerning African parties outside of the African continent. So that was one other data collection that we started doing. And we learned quite a few from that data point, which is, at some point, we see that so many African countries have signed the New York Convention, and by the 90s, a good portion, the majority of the African countries had signed the New York Convention, but many of them were in a situation where their courts hadn't ever seen an enforcement of foreign arbitral award presented for them, right? So we are in the situation where we are very much in the arbitration space and in the framework, but in fact, arbitration happening in the continent was not something that was known. And the only way we were able to find that out is by collecting the data, visualizing it, and then making it available online for everyone to kind of discuss, right? So these were some of the issues that had come up when we started, just from the tech, as in from the data collection standpoint. Now, once that data was collected, a few other things also came up, and this also comes up with regards to, data that's even published from arbitration centers, whether it's ICC or LCIA or ICSID or whatnot. The other challenge that we had was there weren't many Africans being appointed to arbitration, so that there was a huge lack of diversity in that space. And that, again, data collection actually was very much helpful in understanding that, Africa is a consumer of arbitration, but Africans are not included in that space. There's very little representation of Africans in that space. So these were things that came up as we started putting this information together and, kind of having an overall perspective of, Africa and Africans in arbitration. Now, so how does tech fit into this? And what are the potentials of tech to fix or help fix this problem, or actually even make, change the situation as it stands? There's a few points here. The first one is there's been a lot of discussion with regards to blockchain. blockchain being used in the arbitration process, where technically the arbitrator would be, appointed by, the platform rather than the people choosing their own arbitrators, right? So it would be a very neutral way of appointing an arbitrator. And this has been, discussed as a potential diversifier of appointment of arbitrators in the process, which kind of pushes diversity, right? But there's a lot of back and forth about that, in the sense where platform is as good as the coder, and we've seen quite a few developer coder biases in different parts of technology, not just arbitration. And we might still end up in a situation where we're going to constantly keep appointing the same people because they have the experiences, and and those people have the experiences, so they'll keep getting appointed, and others won't. The door won't be open for others. Like, we won't have the possibility of kind of letting new faces and new names come in. So that may not be the best. So that's number one. The second aspect of it is the virtual hearings, and I was very happy to hear about some of the back and forth conflicting opinions on the virtual arbitration space. One of the things that we get challenged on a lot is there's a certain stereotyping of not having arbitrations in venued seated in the African countries, and not even seated, but even venued in different African cities. There's always something always comes up. It's like, no, it's just easier in Paris. The arbitrators are based in Paris, or just Paris is just such a short flight away. Or let's just do it in London, and it's right here, and everybody can just meet there. So the virtual aspect was also a potential that we were very much looking forward would open up and create the potential to appoint arbitrators from around the world to really create some sort of an equalizer opportunity where we no longer have to consider the finances because we don't have to fly them out. We could only just consider the experiences and be able to appoint them as such. Now, I believe that there is a serious limitation with regards to virtual arbitrations as well. If you look at data of appointment of arbitrators, even in virtual hearings, during the COVID years, even in new appointments, the good majority of the centers that have published these numbers show that the diversity has tanked, to say the least. And it hasn't necessarily been the equalizer that we had hoped for, the equalizer that would open up doors to different arbitrators that are from different backgrounds. So I think we have somehow either, I don't know if it's technology that failed us, but it's us that we have failed to use technology in a way that could really open up opportunities. Now, the other issue is in the continent, we have to think about a few things, which is this process of technologies requires a level of digitization and technology that our infrastructure that actually has to be present in our different countries. There's, I'm sure quite a few people have been tested by internet connections during their hearings that were quite frustrating, and hearings being, hearings starting and having to stop because, the connection wasn't good, or the person would be in a very remote area, or there's so much logistics involved in getting the person to get to a place that actually has good connection and whatnot. So that has also been a bit of a challenge. And our courts, for example, different African countries' courts are just slowly moving into the digital space, and that is kind of haggling along, while simultaneously, which is kind of ironic, is there's quite also a few countries that have actually leapfrogged so quickly. And for example, I can even give you the example of my country that you signed a contract with with a big blockchain company where the idea is to sell Ethiopian coffee through a blockchain mechanism where we can connect every bean to which farmer it came from, right? So there's that leapfrogging, but at the same time, our government's still in the process of slowly bringing their technology and their whatnot to the 21st century. So that there's that hold that actually makes it difficult to see so many virtual hearings happening for cases within the continent. So there's that hold back where we want things to kind of be in person. So I think that's one thing. And I don't want to bore you guys too much, and I'm very happy to take questions on this. Is as I said earlier, technology being considered as a big equalizer, and this whole automation process, where we're hoping that it will kind of take the politique out of arbitration and create that equal opportunity and that openness, transparency. I think that's going to be very challenging. I'm a bit pessimistic about that, and I love to be challenged by anyone. But I'm a bit pessimistic about that because so far we have not seen changes. In fact, it's been let's get back to the usual. Let's not even make an effort to be more inclusive. So I find that to be a bit more challenging. Now, the final thing that I want to discuss is with regards to enforcement. So there have been quite a few challenges that we've seen with regards to enforcement of virtual hearing, awards that are coming out of virtual hearing, for example. One of the challenges, at least we've seen in a certain case in an African court, is where the party claimed that they didn't have due process because I'm not sure if you can hear me.
We can.
Okay, great. Where a party claimed that there wasn't enough, they didn't get due process because everybody was in so many different countries, and they weren't able to come up. They were only able to come up with 3 or 4 hours where someone was in China, someone was in Asia, someone was in Latin America, someone was in the US, somebody was in South Africa. So they didn't have the capacity or the potential to have more than a 4-hour or a 3.5-hour long hearing where it would be a time that actually worked for everybody. And it became, and the party kind of challenged the award based off of the fact that, well, that gave the other party more time to prepare, whether it is in witness hearings and whatnot. So these were some of the challenges that had come up during the virtual, as a result of kind of enforcement of virtual hearing. But what we were also hoping with regards to the enforcement aspect and the support of, for example, enforcement of awards is because we don't see so many being actually enforced here on the continent, and so many of the awards are actually being enforced outside of continent. And, and that's kind of one of the legitimacy challenges that arbitration has at the moment, in my view. It's, can we create a space where if we can automize or if we can create a means through which we can enforce directly after an award, or and that enforcement can actually be tied to assets in the continent, because in these disputes, what you have is you have a project that's in Africa, you have a project that concerns African countries, but you end up having disputes and everything that's resolved by non-Africans outside of the African continent. And that really is where I think the basis of that challenge. So if we could figure out a way to actually have an enforcement directly in the space where the project is located, and we can use technology to assist us in making that enforcement and facilitating that enforcement, whether it is smart contracts and tying assets to the contract from the get-go, an asset that's based in the continent and whatnot. I think this could really revolutionize where our courts will get more, let's say, play in enforcement of foreign arbitral awards concerning African parties in their own jurisdictions. So I think these are the ways, in my view, that technology can be used to make the African continent more participatory in arbitration. It hasn't quite worked yet, but let's hope. But also the availability of data and the openness of data that actually has been publicized more and more has shown this where we are, and hopefully that we can use that same technology to make sure that our presence is more felt, and our participation is not just on the bringing business side, but that we actually really do take part in that whole process. So I'll stop here, and if there are any questions, happy to take them. Thank you.
Thank you very much, Leyou. And I think we now have at least a little bit of time, Thijs, for questions, and questions either for Leyou, but also for any of the other panelists. Okay, I see 1, 2, 3. Maybe you start with the gentleman in the back.
Full disclosure, I'm also a software programmer. Sorry, I'll wait for the microphone. Thanks. So again, my name is Martin Beckman. I'm from the Netherlands. And full disclosure, I'm also an IT engineer and a software engineer. And I have a question for everybody on the panel. What do you want? The first thing in software programming is that you establish what is it that you want the systems that we're talking about here to do. I'm not hearing that. And that is very important, because as long as that is not established, we'll keep having discussions about the desirability of using more IT, more systems, more artificial intelligence. We'll never get there.
Who wants to answer?
I'll start then. I think what I was trying to advocate in my talk was the idea that there is no one tool that's going to solve arbitration. In fact, what you need is a menu of suitable tools where you think for this particular arbitration, it would help to have this assistance for these particular parts. So it may be an arbitration where you've got a whole massive volume of documents, and you want some kind of tech-driven, AI-driven ability to break into that documentation in a cost-effective way. But other disputes might be simply about the interpretation of a particular clause in a contract. And you don't need any of that technology. So I think it's more about people will come up with solutions to deal with particular problems. And we've just got to be ready for the fact that there will be a menu of things out there. And if we're serving our clients best, we're going to be telling them about those different options which can save them money and deal with the dispute in a cost-effective way.
I hope I'm allowed a follow-up comment.
Yeah, yes, you are.
Okay. I'm going to repeat my question. What do you want? Because you're talking about a menu. I actually agree with you. Who is going to write the menu?
Aija?
I mean, first of all, I can't believe there was a programmer here. Thank you for standing up. But I think the main issue is that I'm going to respond from the smart contracts perspective, but also from any type of perspective, like what do you want? It's always what do the parties want? What does the client want? And it's sometimes very difficult because they don't always know what they want. So for instance, from a smart contract perspective, I think it's probably more adapted right now to sort of straightforward things, or to, I don't know, a real estate deal when this money goes in, this happens, the deed is issued, or things like that. Because even when the parties have sort of 50 or 150 pages to do their contract, even then they don't sometimes know what they want. So I understand your frustration.
Okay, I think the second person.
Sorry, just
please.
one comment. What I want and what is it on?
Yes.
I think many arbitration practitioners want as well that for arbitration to stay human. And it's very important to keep, for example, when you have a tribunal, three-person tribunal, when they meet in person, it's completely different energy and different exchange. And the same to have hearings in person. Of course, like for different, sometimes small claim does not mean not sophisticated legal issues. So I think that we are thinking about technology to advance, but we are human and we live and we have like simple pleasure of having a hearing, a physical hearing, or just to not to think that every aspect of what I'm saying or I'm doing is monitored by an artificial intelligence trying to calculate what will be the outcome of my decision.
Thijs, I think the next question was just next to you, and then we have Jakob afterwards.
Hello, my name is Alexandra Hnatiuk. I'm from Kyiv/Berlin. I'm Indian Square Button Box. And I have a question to Ms. Aija. You thought that this special type of arbitration, the words in the special type of arbitration, they are executed automatically. Could you please clarify what does it mean? Things like, either it means that like, they are executed at the same moment when the word issued, or like automatic execution means that there is no need to open executive proceeding, but like there is special period of time when party actually can appeal the decision. So I'm asking things, I'm curious whether there is opportunity to appeal the decision of tribunal. Things like if the first variant of and model of execution without like with executing at the same time when the word is issued, so like actually parties do not have any right to appeal, or?
Thank you, that's a great question. So that would depend on the specific agreement. Basically, on-chain arbitration means that everything's already, for instance, if the dispute is about $1 million in crypto, so the parties would put that crypto in a crypto wallet with a specific address that everybody would know, and upon the decision of the arbitrator, the decision would be encoded on the blockchain where that crypto is, and there would be automatic execution. Now, you could have the possibility of some sort of appeal, but that would have to be part of that agreement. But the whole attraction of it's kind of like holding money in an escrow, and the moment the parties say release the money, it gets released. It's kind of the same thing. But it immediately happens because crypto, not immediate, there's a couple of seconds of a lag, but it's sort of, you don't have to spend 2 months, 3 months chasing anything because you already have the assets and they automatically get transferred.
I think next one was Jakob.
Thank you. I have a comment/question, and maybe the first one to Anna, because we were talking about the tokenization of assets and also the tokenization of funded cases. Full disclosure, we don't tokenize the cases that we invest in, but except for the Aija Labs project that you have been talking about, there's also another company that is active in the field, and that's a Swiss company. It's called Leyniece Capital. And you have been talking about that. There is a possibility to look up on Etherscan how a particular coin is developing. So if you look up on Etherscan how the Leyniece coin is developing, you can see it has been very slow to take off. While at the same time, I know from personal discussions with the company that their funding business is going really well. So it may be an indication on the tokenization aspect of funding. The other comment is going to Aija, and I was wondering whether you have any, or maybe not only to Aija, but to everybody, but I was wondering whether you have a view on the crowdsourcing or the crowd justice project on the blockchain that's called Kleros.io, because personally I see it, well, this project is based on the fact that laymen come to a decision on a particular dispute, and personally I find it, well, concerning that it's being done, and I'm just wondering whether people are aware of it, that something like this exists, and what your view on this is.
Okay, thank you. That's a Do you want to take the first one?
Just a small comment. I think that now we have more and more webinars, different initiatives. There is ArbTech that just explaining towards what is blockchain, what technologies are used. And I think that here, and as Aija said, that it's completely different crowd. And we attended this conference together, and when you go there, you see people wearing T-shirts, hoodies, and they're just like...
My favorite is a hoodie, and then on top of the hoodie, there's a jacket, and there's mismatched socks. That was my favorite.
So it's just completely different industry, the different vision. It's like more like IT guys who became millionaires quickly, and they're still passionate by their profession more than by money, majority of them. So I think that what is now very important is to create a bridge between crypto community and lawyers. So for us to understand better not only the technologies but their way of thinking. And I think that Claris, as far as I remember, there was a conference in Paris maybe 2-3 weeks ago, so the head legal was invited as a speaker. So I think that they're trying also to spread information to the lawyers community.
Before I get into Claris, just a tiny comment on Liddy Capital. I've worked with them. As far as I've been told, they are the first ones to tokenize, but I think one of the reasons they wanted to tokenize is that they kind of focus on blockchain-related disputes, so it was part of the game. But speaking about Claris, I think it's very difficult to see people not being able to access justice. So to the extent that if it's a small claim and that allows people to resolve their dispute and actually get some money back or have the chance of getting some money back, I think that's great. Because I've seen, ever since I've gone solo, I've seen so many times when a client has a decent case, they just can't get the funding because it's not big enough or they don't have the funds themselves. And it's really, really frustrating. And a lot of times in these crypto spaces, you'll have small claims like 5,000, maybe 10, and it's just not worth going the regular arbitration route. I myself was involved in a case where going to arbitration would cost 60K. People, if they lost 20K, people don't have 60K lying around somewhere just to put it into an arbitration. But there are, I think, with Claris, the main issue is that the arbitrators get compensated not based on the fact that they participated, but based on whether they decide like the majority decides. So that is kind of like a very weird incentive to participate, but at the same time, if you look at the US legal system, they have jury trials. I don't think those people are, much more qualified than the arbitrators or jurors on Claros. So it's I mean, it's one of these modern things that keep popping up, and I think we as the arbitration community, if we would participate in those procedures more, maybe we could convince them at some point to have, specialized arbitrators where people would be, more competent and maybe change also the way that the arbitrators are compensated. Thank you.
Over there, Thijs.
Pierre-Olivier Savoie from Savoie-la-Porte in Paris, and I want to challenge Leyou's pessimistic view on the future, virtual hearings, inclusivity. And I think my comment also goes to James's presentation in terms of who likes virtual hearings, who's ready to do them, and perhaps there's a generational question in terms of who wants to do it, although, I mean, let's be inclusive about who wants to do virtual hearings. However, I've started sitting as arbitrator a few years ago, and as sole arbitrator and presiding arbitrator, in addition to mainly counsel work, but all the hearings that I've had have been virtual. I love it. It's fine. It goes just well, and the last one, I was in Paris, the administrator was in the Caymans, the barristers and solicitors in London, and another set of solicitors in Dubai. It was a 2-day hearing. Are we going to really fly everybody somewhere? And to add to that, as counsel, I did an OHADA arbitration in English, mining. Opposing counsel was based in Kolwezi in the Democratic Republic of Congo, and during COVID we did a couple virtual hearings, and it went very well. So, it's possible. So if people want to do it in the appropriate arbitration, sure, I'm ready for it. and hopefully everybody else is, if you're going to have a 15-day hearing, maybe we can consider meeting all in person, but in the appropriate case, absolutely.
Leyou, do you want to respond?
Yes, I think what the examples you've mentioned are actually quite fantastic. My only challenge is considering that the technology is so much more available now and so much easier and so much more affordable. It should have been happening a lot more. It's just that thing where I feel that we can do it, but we're not doing it enough. And it's that, are we going to do it more than we usually do it? Like I mentioned, the data shows that the appointment of African arbitrators, or even arbitrators of African descent, has gone down during COVID, where virtual hearings have gone up. It's just these things that kind of I find quite scary. But there is a lot of situations where it's also made it very possible for people to be on virtually. So let's hope that there is more openness and actual dedication to really using the internet and the virtual world to expand that. But yeah, I'm glad. Thank you for your examples. I appreciate it.
Very good, and I think we're going to finish on this positive note. Many thanks for the audience for putting the questions, but also many thanks for the speakers and providing us with your insightful presentations. Leyou, for joining and being with us virtually this morning. I think the speakers deserve a final but nevertheless broad round of applause, and then we move on to coffee.
Recovery, and you look great, so I hope you're not really sick. You just got a little bit of COVID. Okay, see you next year in person. Okay?
Yeah.
All right. Thank you, Nils. Thanks to the speakers. And now we're going to take a little trip to another part of Europe, to Scotland. And Andrew Mackenzie is going to introduce us to ICA. Henry, if you want to come up to the
apologize, Andrew, I almost stole your slot, and the rest have to bear with me another 3 minutes. But I'm sure it will be worthwhile that we wait for the coffee.
Absolutely. So we fast forward to the next conference, which is going to be in Edinburgh. Very much looking forward. And Andrew is going to explain what's going to happen.
Thank you very much, Thijs. And thanks very much for allowing me this opportunity to say a few words about the ICA Congress that, as Thijs was saying, will happen in Edinburgh in September, the 18th to the 21st of September. You might wonder why I'm here to talk about another conference, but it is, I think, for the arbitration community, a very important conference happening every 2 years. Over the last 50 years, it's been the place where some of the big discussions have happened in international arbitration with some of the leading lights. I remember being at ICA Miami in 2014, where there was a discussion on diversity that then led to a number of initiatives, including the Equal Representation Pledge. So it is an important congress, and I hope you will join us in Edinburgh in September. We already have over 700 delegates. I hope we will have over 1,000. It'll be a big event in Scotland, and I'm going to share with you the video that we prepared for the Congress, the welcome video. It's a bit out of date now because we had to postpone the Congress for a number of times because of COVID, but ignore some of the dates. The people are all still around, including our First Minister, who will start the video. So if I could just ask the people to play the video. And thanks again for this opportunity, and please do join us in Edinburgh if you can. Thank you.
Scotland is immensely proud of its long history of arbitration, spanning some 700 years. The Arbitration Scotland Act 2010 has enabled us to have one of the most modern systems of arbitration in the world. I consider arbitration to form part of our business-friendly environment. Furthermore, the Scottish legal system is held in high regard. With its continental roots and common law influences, it has contributed to international principles of law.
As a legal jurisdiction, Scotland has a mixed system, much in the way that international arbitration might be described, with common and civil law influences. An example of this is our restricted approach to document discovery, in contrast to our English neighbours. Scotland is an open jurisdiction, and there are no limits on who may appear as counsel in an arbitration or as an arbitrator. The Scottish courts have adopted a supportive but non-interventionist approach to arbitration under the Arbitration Scotland Act 2010. Appeals against awards, and indeed any court involvement in an arbitration, are dealt with by a streamlined process under the specific court rules related to the Act. Applications are dealt with by specialist arbitration judges appointed by the court. Parties' names are anonymised on request, and related proceedings take place in closed court. Last year, the court established an arbitration court users group to provide a forum for consultation, discussion and feedback between judges, legal professionals and others involved in arbitration matters in Scottish courts. All of this illustrates Scotland's continuing commitment to ensuring that it has a strong arbitration system to offer to the world.
Scotland is one of Europe's ancient nations, and arbitration has been practiced here for many centuries. It has been a familiar part of our legal culture since the Middle Ages and has always had an international outlook. However, in terms of modern international arbitration regime, Scotland is very much an emerging nation. We are an independent arbitral jurisdiction, and if we were an independent nation, we would have the 15th largest economy in Europe with a GDP of $228 billion a year. Our economy is diverse. We are a major financial centre, a centre of biotechnology, computing and video game technology. And of course, we're a centre of energy production, both in oil and gas and renewables. In 2020, as well as hosting the ICA Congress, we'll be celebrating the 10th anniversary of the Scottish Arbitration Act, which provides a modern and easily understood framework for international arbitration. We do hope very much that you will join us for these celebrations.
Making connections delivers results, and there is no doubt in my mind that the Scottish Arbitration Centre is spreading Scotland's arbitration message more widely than ever before. Edinburgh, our capital city, is ideally placed to host the ICCA 2020 Congress, with the facilities and professionalism available in the city acknowledged by the meetings industry worldwide. I know that all the partners in Edinburgh will work to ensure delegates are given every assistance to make the most of their visit to Scotland, and that all your delegates will experience the heritage, the culture and the activities that can be found throughout our country.
Now is the time to look to Scotland.
Thank you. So this definitely will be another conference worthwhile, participating in another beautiful city. And now we take half an hour break. See you back in half an hour.